Welcome to Season 1 of Margin Talks by Finneloop, where we help explore the flow of money in e-commerce. Today I have Sam Lockwood-Powell on the show. Sam is the managing partner at Spyglass Law and has probably seen more sales and purchase agreements of sub-$50 million emerging brands than anyone I know. He was previously at Big Law at Kirkland & Ellis and more recently has been advising emerging brands on both sales and purchases, as well as special situations and restructurings. Sam, welcome to the show.
Dan, good to see you. Thanks for having me.
So today we're going to start off with a spicy topic, which is the situation of bench accounting. It's relevant to the e-commerce industry for two reasons. First of all, they have a lot of e-commerce clients. And second, and potentially more importantly, it's a lesson on the role of senior lenders in businesses and what can happen when things happen to go sideways. Sam, my first question to you is, word on the street is Bench has a senior lender and had a default that cascaded to their eventual shutdown. What does it mean to be a senior lender? And what rights do they typically get?
Yeah, I don't know necessarily for the bench situation specifically, right? But in general, a senior lender is typically just a financial institution, just like any other lender that's providing money to a borrower. The senior tag there and kind of the critical component that likely applied with bench in terms of how you become a senior lender, it really just comes down to their security interest and the priority of their security interest. So a business might have 4 or 5 different lenders. But one of them is typically considered senior if there's a few secured parties. And how a lender becomes senior typically is 2-part. One, you enter into the loan agreement, security agreement directly with the borrower, right? That's a private commercial contract. And then the second piece is perfecting that interest. And that's really the most important part, is going and filing, what's called the UCC financing statement, typically with Delaware or wherever the company is incorporated. And that puts the world on notice that that lender or that institution has a senior priority in the collateral that they describe, which is typically, all the assets of the company. And they do that so that they have let other lenders or other equity investors or whoever know that if things do go sideways, like we know can happen, then they are the first to recoup based off of those assets or are entitled to that collateral.
Is it similar in that way to a bank being a lender on someone's home purchase, and that if in the event of the default, the bank can take over the home?
Yeah, that's a really good analogy. It's very similar to that, right? So here, a bank, similar to the example you just laid out, if you don't make your mortgage payments, you're in default with your bank on your mortgage, they have the right to repossess your home, right, and foreclose on your home. That's exactly what's happening here with these small businesses, big businesses, everything. Where a senior lender, if you default on the loan with them, say you don't make a principal payment last month, or you break some of the covenants that might be in an agreement with a senior lender, they have the right to foreclose on your business and take over the assets. And what they choose to do with those assets, they can operate them loan to own, or they can sell them off to a buyer, which is really common, especially in today's day and age. So yeah, very, very similar to that.
And how does the lender enforce their rights? With a bank, there are a set of keys that presumably they can take over. The keys for a business, whether it's a tech-enabled accounting business like Bench or an e-commerce business, it's a bit more complicated. So they default, but how do they actually foreclose and enforce their rights?
Yeah, it's a lot more complicated than just tossing the keys on the table and saying take it over. Because as we know with e-com, there's a million different passwords, a million different platforms and ways to actually operate the business. So getting those tactically transitioned over to a lender is very, very difficult. But in theory, how a lender would go about kind of acting on a default, right? There's multiple different ways, but from a legal perspective, you enter into technical default. That's the first kind of step, right? So I said an example earlier where you might miss a principal payment. Well, when you miss that, you're in technical default, which just means, hey, you've explicitly violated the agreement, and the lender has the rights to default on your company and take control of the collateral. Now, whether they do that immediately or you negotiate with the lender because you're hitting a rough period, who knows? But that's kind of that initial step. The second step that really comes into play is when you start negotiating with the lender and kind of discuss like, look, we don't know what we're going to do. We theoretically are handing you the keys, right? So the lender is going to issue a notice of the default to other secured parties. And that's kind of the trigger and the starting period of what we call an Article 9 foreclosure. There's a bunch of different nuances with what an Article 9 foreclosure kind of entails. But at that moment when the lender, one, sends a notice of default to the borrower, but then two, kind of puts, to the earlier illusion of putting the world on notice. That's what this notice period does, is putting other creditors, senior creditors or junior creditors, on notice that the senior lender is going to enact and pursue their rights under Uniform Commercial Code, Article 9, to take control of the assets and then potentially sell and potentially run it as, in-house, whatever it is. So that's the step 2. And then step 3 is, that third part of, are you going to sell it to a neutral third party buyer, like presumably Bench did, we don't know, or are you going to, run it in-house? Some lenders I've seen and heard have, operations teams in-house where maybe they can't find a buyer in that specific time frame. So they want to, continue operating the business because they don't want the business to completely deteriorate, because that's their assets where they're going to, receive value in exchange for the loan, kind of get made full. But that's kind of the third step after the foreclosure process starts.
You mentioned that the senior lender has the technical default, then they start the foreclosure process. And you mentioned that there are sometimes people junior below them and potentially even unsecured lenders. What happens to junior secureds or unsecureds once a foreclosure process starts?
Yeah, it's a tough situation if you're a junior secured, or especially if you're an unsecured creditor in an Article 9 transaction. So the short of it is they're kind of wiped out, right? It depends on what the consideration is. So let's stick on an example of lender A defaults on borrower agrees to it. They send out the notice to junior secured, and the lender decides to sell the assets to a neutral third party buyer. Now, depending on what the value of the note is and, what the borrower or the lender and the third party are negotiating in terms of the purchase and sale, any excess consideration, could flow to junior secured. Very unlikely that would happen, right? If a business is so impaired that, the lender is foreclosing on it and selling it off, it's unlikely that the assets would exceed the value of what that senior note is, but it happens. But from an Article 9 foreclosure, what legally and theoretically happens is anything below the senior level is effectively wiped out and would take a zero.
So with Bench, they announced the shutdown around the week before Christmas, I think. And then it went pretty viral. A couple of days before New Year's, they announced that it's sold to employer.com, which is a brand new startup itself. Transactions like this we've seen, there's usually maybe buyer stock that's issued, especially since it's employer is a startup itself. Now I'm completely speculating, but it's most likely the senior lender here was impaired, and that everyone below that, if Bench had a landlord or had other AP, all of that is washed out in a foreclosure sale.
Yeah, technically that's correct, right? So this is where when I'm talking with clients or, in these kind of situations, there's the legal considerations and then there's the commercial and more practical considerations. So legally, yes, AP, let's say your supplier, you owe them, the company owes a supplier $500,000. That technically is wiped out, right? But now let's move over to the commercial side. Well, an Article 9 doesn't mean that you can just automatically force that supplier to take a zero and continue working with you or working with Newco. So when a buyer is working through an Article 9 transaction like this, yes, they're able to get the assets free and clear, but there's all these commercial practical considerations that you have to take into play. The 3PL is a really good example. A lot of folks get into troubles with their 3PL. They rack up a pretty big balance. Is that debt wiped? Well, they might have a warehouse lien, et cetera. But for the purpose of this, let's just say it does get wiped and they don't have any security. Well, you still kind of need them to continue operating, right? In order for the business to continue in ordinary course. So that's where a buyer from the lender or the buyer who's buying the assets from the lender would need to negotiate directly with a lot of these third parties, especially what I like to call the critical operating parties. They either take, a negotiation on the balance, amortized schedule. Maybe you can afford to pay it down directly. And that's all part of the calculation before you kind of go into this process.
So we've got Jacob here from Finneloop. It's been a busy week or so. I know the whole Finneloop team has been heads down onboarding customers from Bench. Give us an inside scoop on what's been going on.
Yes, regarding the whole Bench story, it's been a real whirlwind and really on the front lines here. First of all, we were pretty shocked when this happened. Bench is a big player that's been around for a while and services thousands, maybe even tens of thousands of customers. So it kind of, for us, came out of the blue that all of a sudden they were announcing being closed and then being bought out, then not being bought out, being bought out. It was a whole big mess. That was just our initial reaction. And then we kind of got on our feet and decided we're going to try to help all of these people that have been influenced by this situation in the world of e-commerce, right? To Finaloop, we work with e-commerce customers. So we can't help a good chunk of the folks who were using Bench, but definitely the e-commerce ones are right up our alley. So we've been working nonstop. Our onboarding team, everyone's been all hands on deck we're speaking to lots of people, helping them on board, get their finance and eventually tax records up to date as soon as possible. Everyone knows that deadlines are coming up. 1099s are just around the corner at the end of January. So really trying as hard as we can to help all of these customers, some of them who kind of have misgivings now about Bench in general, about the new acquirer who is a newly formed company, doesn't exactly come from the bookkeeping space. And especially since our founder, Leo, comes from both the world of accounting and the world of DTC e-commerce, we felt the pain of these Bench clients who all of a sudden on December 27th, right before year end, when you're supposed to be having a nice family time, all of a sudden have this huge shock of your provider going out of business, which gives lots of lack of certainty and fear of just lack of stability and not being able to meet all of your deadlines and use your financials as you should be. So we kind of stepped up to the plate and have been helping lots and lots of people who have been put into this tough situation. And we're definitely open to helping anyone else who is in the world of e-commerce and was previously working with Bench to help them get everything in order and meet all of their deadlines and requirements.
You've seen foreclosure sales, which is mostly what we've been talking about today, but there's also assignment for benefit of creditors, there's Chapter 11s. What are the different parts in a tricky situation?
The way I kind of break it down is, you're right, there's the 3 different tools, and there's a ton of other ones too, but these are the flagpoles that I say in this kind of e-com space. And it's the A9, the ABC, and then Chapter 11, and I'll get to kind of the thresholds for each. But for an A9, that's typically when folks want to move really quick and are relatively cost sensitive. You can do it from a legal perspective in a pretty cost effective manner in comparison to some of the other tools, the ABC and Chapter 11. And the biggest thing here is it's an out of court proceeding, right? It's governed by the Uniform Commercial Code, Article 9, and the rules and regulations therein. Whereas an ABC process is kind of one step further, right? So that's a state law insolvency proceeding. So effectively what's happening here is a debtor is going to voluntarily transfer the assets to an assignee, a neutral third party, trust administrator, whatever you want to call it. And they will then run a process, a marketing process, et cetera, to kind of liquidate those assets for the benefit of the creditor. So you have $1 million of assets, you got $5 million of debt. They go liquidate it for $1 million if they're lucky. And then those proceeds are distributed, down the waterfall. So that kind of goes to the importance of the senior lender, right? They're kind of first after administrative costs, and then down to junior secured and unsecured on a pro rata basis, et cetera. So that's what an ABC, how that sort of plays out. Timeline there is a little bit longer than in Article 9. I've seen them last upwards of a year, whereas in Article 9, you can usually, from the moment of foreclosure to the sale, it can happen if you really, really push in like a 20 to 30 day period. So there's, kind of a nuance there. And then the last kind of like big elephant gorilla in the room is Chapter 11. So that's, as you know, a federally court supervised organization, follows the bankruptcy code. And what this does is allows for the restructuring of debt while you're still continuing the operations of the business. And the benefit here is you get an automatic stay against creditors. So therefore you can continue operating with an Article 9. In comparison, you still have creditors reaching out to you, kind of like asking for the world, and you can't give them much. Here, Chapter 11, you're actually getting formal protection from those creditors. And then there's a little known tool under Chapter 11 called Subchapter 5, which is effectively kind of a carve out of Chapter 11 for small businesses. This was utilized really heavily post-COVID when I believe it was the CARES Act, kind of upped the debt limit. So there's a debt threshold, but it upped the debt limit to, I believe it was like $7.5 million. So if you had debt that was at $7.5 million or below, you could use this Subchapter 5, Chapter 11 tool, which effectively is just a streamlined Chapter 11 process, a little bit cheaper. But the kind of con here with Chapter 11 and a formal bankruptcy proceeding is scrutiny, but then also cost. It does cost a lot of money. Legal fees are expensive, administrative, you typically will have a CRO come in, you got to pay them for kind of an independent, neutral third party to run the business. So unless the business has a sufficient amount of cash and runway, this is a tough one to go through, especially in the small e-com world.
For all of those listening that may be in technical default or concerned that they're headed that way, it sounds like all of this is pretty nuanced, all of this is pretty complicated, and that they should engage a lawyer as soon as possible. Now, not to overly pitch your book, Sam, but are there specific lawyers that an e-commerce business should be thinking about engaging, or can they use their general counsel that potentially did their fundraise or even incorporation prior to that?
That question, while there's all these tools, those are nuanced. That question as well is nuanced, right? It depends on what they're looking to do. If they're trying to get restructuring advice or special situation advice is kind of what I call it. I think that typically you'd want to have someone that has a little bit of experience in the arena. I'd think that if you have a lawyer who predominantly has practiced family law for 30 years or predominantly done trust and estates, et cetera, you're not going to want to engage them to, negotiate with lenders, run an article line process. Likewise, if you need a family law attorney, you probably wouldn't want to hire me to do that because that would end horribly. So I think that there's a bunch of different nuances there, but yeah, I think in large part, it is beneficial to have someone with a lot of experience, or at least some experience in this arena before going forward with it.
To change track slightly from restructuring to sales and purchases, what are the major milestones of an M&A or exit process, and how long does it take?
Yeah, so just for a traditional M&A, there's really three big milestones, I'd say, from a legal perspective. Obviously, there's a ton on the commercial side as well, but the three big milestones are an indication of interest, or an IOI, an LOI, letter of intent, and then a purchase agreement. And so before I dive in, all those three things are kind of happening in parallel with, commercial due diligence, management calls, et cetera. So you're kind of all marching towards the same goal. But on that vein, right, so the first kind of bucket list or ticker is the IOI. So that's where a seller's running a process, going out, whether they hired a banker or running it, just through word of mouth, et cetera, running a process to see what is the market saying. Is there interest? We're going out with a specific price. This is what we're looking for. We're on, maybe you want to say the specific structure you want, et cetera, but just engaging with a bunch of parties. And that's, limited diligence, et cetera. That timeline varies, right? You could start a process and it could last 30 to 45 days before you ask for folks to submit IOIs. And then when they submit an IOI, what that really says is, hey, this is the price that, we're interested in or okay with. Here's, maybe a summary of some of the terms in a potential LOI or purchase agreement that we would want to include. And that's why it's really important to have a lawyer at least help or advise. You don't need to have them completely drafted up, just being practical here, but having them just kind of sign off on it so you're not submitting something that maybe is going to bite you in the butt later. The big thing here with an IOI is usually there's no exclusivity. So a seller is running the process and gathering, let's say 5, 6, 7 IOIs in a good situation. And then from there, that really helps the seller just narrow the focus. So let's say, you get that within 30 days, then the next, let's say 30 days or so, 30 to 45 days, if you're moving on a regular timeline, I've seen it much quicker, but just for the purposes of example, you're marching towards an LOI. And during that time period, what that means is, the business folks are continuously discussing, management calls, doing more diligence, et cetera. But then that's really when legal gets involved as well, starting to do legal diligence and focusing in on a lot of the key elements there from a legal diligence perspective, all to get to an LOI. Once you get to the LOI, that's where the seller typically will be going exclusive with one party. And so then once the seller and the buyer or whoever the selected party is go exclusive, they will have anywhere from, let's say, 30 days of exclusivity on the low end to, I've seen 60 to 90 days on the high end. That's usually for bigger transactions and a bigger enterprise value. And during that time frame is when, the purchase agreement starts. Things are starting to get a little bit more serious, and folks are all working towards a close, unless something big comes up. And that's also during the time frame when the purchase agreement's being negotiated between the lawyers and the commercial folks too. So all in all, I think from start to finish, a typical small business transaction can last anywhere from, let's say, 2 months to 4 months. But sometimes you need it quicker, and you can get it done in 30 days.
To put you on the spot with a question that every service provider hates, we talked about the duration But what about costing? So there are a lot of listeners here that are probably in the $1 to $10 million revenue range for, with regards to their e-commerce business. In an exit process for brands that size, are we talking tens of thousands, hundreds of thousands? What should they expect in terms of legal fees?
Yeah, for the folks that are in the 1 to 10 million range, I think that's where you're really starting to benefit from working with, solo practitioners or folks like myself. There's a million different people that are offering these services in this space, but that's where, the differentiation comes into play is largely on the cost side. So it's definitely the former, the tens of thousands. And very rarely would I envision a purchase or an acquisition of sub $10 million to be more than $100,000. That'd be pretty crazy. I would say, it varies deal by deal. And of course, don't want to quote it like you typically would say, but anywhere from 15 to 35 or $40,000 for a bread and butter M&A transaction is kind of right in the wheelhouse. And of course that varies. People do fixed fee, people do hourly. But when I'm working with clients, I really just try to focus on what's the most practical. Is fixed fee better for everybody? Is hourly better for everybody? What is my role? Sometimes they have, tax counsel in-house, all that kind of stuff. So it can change and vary by deal.
No, I appreciate you sharing that. What do e-commerce sellers get wrong about their sale process? I know that you've seen so many of these and each one is different, but what are some headaches to avoid?
It's a really good question. I don't know if it's necessarily that e-com sellers get things wrong, but maybe there's just misaligned expectations when you go forward with the process. So that I guess the two big things I think of are pricing expectations and then ability to close. So a lot of folks,
10x revenue is the standard, right?
Exactly. Yeah, I've been hearing 15 to 20, but we'll see what happens. Yeah, so I think pricing expectations, you read all this stuff on X, on, Substack, whatever, of these big exits. So folks get that in their mind that we should be transacting for 10X because, I poured my blood, heart, and soul into this business for the past 7 to 10 years. And while sentimentally I might agree with you, the market might say otherwise. So that's kind of the big thing is if you're running on a process, try to be as pragmatic and realistic as possible. And I think that starts with getting good guidance from friends or, folks in the community who have maybe transacted in a similar space that you have, or just hearing more about, what the kind of realm of TV is, can really help avoid any kind of pitfalls once you start the process, right? Because once you start the process and you're having all these management calls, you're investing a lot of time. Not only are you continuously running the business, but you have to make time for discussions with the seller or buyer and all that kind of stuff as well. So you don't want to waste your time or other people's times as well. And then the second big thing that I think is actually quite misaligned is the ability to close. A lot of folks will start the process and think that, if I start the process and I align on price, it's as good as done. That's often not the case. The thing that I've noticed the most is, there's a lot of large institutions who might come in and offer one price, and then a self-funded searcher or something will come in and offer something a little bit higher. But the indexing towards the ability to close, so whether the individuals have closed on transactions before or not, is kind of one thing I would focus on, and a little bit of a reverse diligence. Because I've seen it where, you get 60 to 90 days down the road exclusive with the party, and then the buyer pulls out for one reason or another. And maybe they had a better price, but the other, party was offering 10% less, and there was a lot more certainty to close. So yeah, I don't know if that's necessarily things to get wrong, but just like the expectations for sure.
And especially in the small market, again, sticking with the $1 to $10 million revenue range, I would argue that ability to close probably even trumps price, because the buy side in that market, more often than not, I'd say the median buyer in that market is a first-time buyer. And so your first-time buyer meets first-time seller, it can get interesting.
It definitely gets spicy. There's no doubt about that. And I think you're absolutely right that the ability to close, in my mind, should be one of the biggest things when folks are going from an IOI to an LOI, because that's where you're committed, right? And I'm not a founder of a traditional e-commerce business, but I've worked with enough and been engaged with enough to know the sentimental feeling that folks have when they're ready to let go of the business and move forward. And it really, really sucks when you think you're ready to go with the party, you get 60 days into exclusivity, and the buyer walks at the 1 yard line. So yeah, just pressure testing that is absolutely critical to the whole process.
You've also invested in a number of consumer brands and sometimes even gone beyond your legal scope. How has that informed your view on consumer brands?
Yes, I have. Yeah, I think it's nuanced in the sense that operational support and investing, in my mind, makes not only being a lawyer and assisting on deals easier, but a little bit more enjoyable. And what I mean by that is if you kind of take the next step and you've been in the weeds working as, a chief of staff or a manager or whatever, and know where the pain points of a business are, it helps the process in terms of, going forward with the purchase agreement and everything like that, because you know exactly what to look for. And what I mean by that is, if you're someone who has been an M&A lawyer for 25 years and worked only on manufacturing deals or only on oil and gas, you might not know some of the nuances that come from an e-com deal. And likewise, an e-com person or e-com M&A lawyer might not know the same about oil and gas, or wouldn't for sure. But there are hyper nuanced things with e-com, like sales tax is a huge one, right? If you've operated in e-com, you know how big of a pain that can be. And if you're running through a purchase agreement, like that's one of the big things that I'll see for folks that maybe haven't done e-com deals before. They'll just kind of gloss over and not even ask about, when we know how big of a problem that can be. So yeah, I think operational support and kind of getting the commercial hat on while also having the legal hat on is beneficial for everybody. It helps you ask the right questions and dig into the right things, but then also just makes it more enjoyable because you feel a little bit more a part of the team. Sometimes lawyers can be off on their own little island. So if you know what's going on from a commercial side and being able to read financial statements and do all that kind of stuff to make sure you're looking for the right stuff definitely provides a leg up.
Jacob, Sam here talks about the complexity of sales tax in e-commerce. Can you help us elaborate on this?
Yeah, so sales tax is pretty complex, one of the most complicated topics within e-commerce. So first of all, it's a tax that's imposed on the sale of goods or provision of services, and it's on a state level, meaning it's not a federal tax, it's a state tax. So each state has their own rules, laws, and regulations as to how that tax works. Some states don't have any or limited sales tax. Some states have sales tax holidays, certain periods where sales tax would not apply, or certain items that sales tax would not apply to, certain groceries or medications, etc. And it's really difficult to stay on top of your sales tax. Now, this was difficult in general, but it was compounded in 2018 when there was a famous case called Wayfair, which pretty much said that even if you don't have a physical presence within a specific state, if you have significant economic activity, like if you're selling online, then that can give rise to sales tax liabilities. So a lot of states now have various nexus rules, meaning how connected you are to the state, which would generally require you, if you meet those nexus rules, to register and to remit state tax upon sales that take place within that state. It's not going to dive into it now. It's a very broad topic, but in general, if you have certain economic activity, generally either a certain amount of transactions, like 100 or 200 transactions, and or a certain amount of sale threshold, 100,000 or 200,000, some states $500,000, then you are subject to sales tax in that state, even if you have no physical activity and no brick and mortar, no warehouse in that state, but you'd still be subject to sales tax within that state based on your economic nexus. There always was a physical nexus, meaning if you're within that state, you generally have certain liabilities towards sales tax. There are all kinds of other rules, such as marketplace facilitators, which generally means that if you're selling on a marketplace, like Amazon, let's say, for example, then in general, they would be taking care of the actual remittance of sales tax. You might still have registration requirements, but that's as opposed to if you're selling through your own shop, let's say through Shopify or something, then in that case, you'd be responsible for dealing with sales tax. There's all kinds of softwares out there. Some of them are better, some are worse. They all require knowing how to work with the software and being very on top of it. But that's kind of just a view from above on what sales tax looks like. And just one last point, kind of touching into the topic of this podcast, certain times when you have an acquisition of an entire business, I mean, if you're doing not an asset deal, but a share deal, then you'd have reps and warranties and you wouldn't be necessarily getting the tax liabilities that exist within a business, as they'd be included under the reps from the previous side of and moved on to the seller or remaining with the seller. An asset deal, some people think when you just buy the assets, you don't even have to deal with that at all. But if it's a full business succession, then in a lot of states, the sales tax liability would actually move on to the buyer. So that's just another point that's worth keeping in mind when it comes to sales tax.
As we head towards a wrap, this wouldn't be a consumer podcast without asking, Sam, what's in your cart these days? What are purchases that you're pondering?
Great question. What am I planning? Well, I just got a Therabody eye mask thing. It does a massage on your eyes and heats it and cools it, and you can listen to some music if you want to do meditating and everything. So I just got that. Was in my cart for a while. Just got that for Christmas. So that was a nice little gift. Otherwise I have 2 dogs. So I'm always looking for pet supplements or pet toys or anything like that. That's typically what I'm checking out on a daily or weekly basis, unfortunately. But no, there's a lot of cool brands coming out with cool stuff, and eager to see what progresses over the next year.
For brands interested in selling or exiting or asking for legal advice, potentially they're in technical default, how should they find you?
The best way to reach out to me is just via email, sam@spyglasslaw.com. And happy to always hop on a call, do a consultation, hear what the situation is, whether it's me or whether I can refer you out to somebody else who might be better fitted. Always happy to take that call and help out as much as I can.
Sam, thanks so much for sharing your knowledge with all our listeners. Can't wait for next time.
Yeah, thanks a lot, Fan. We'll talk to you soon.
Thanks for listening to Margin Talks by Finneloop. Don't forget to like and subscribe on the channel you're listening to. If you have any questions or feedback, feel free to email me, fan@thehedgehogcompany.com. And if you'd like to see what Finneloop can do for your e-commerce business, please visit finneloop.com. We'll see you on the next one.